This is In Your State and On Your Screen, your no bullshit guide to how your state is or isn't protecting your digital rights. So today we're focused on California, the blueprint state, and this is a longer video, so please bear with me, okay? The backstory. So it all starts with a guy named Alistair McTaggart, I think that's how you pronounce his name, a San Francisco real estate developer. And a few years back, he went to a dinner party and he ended up chatting it up with a Google engineer who ended up saying, if people understood how much we knew about them, they'd probably be really worried. Well, that definitely got Alistair worried, so worried that he launched a citizen initiative. And if you've never heard of that, it's basically a petition on steroids. So instead of being something to just raise awareness, it's a legal process that lets everyday people propose a law to get it on the ballot. He gathered over 600,000 signatures, enough to get the initiative on the ballot. And that's when lawmakers started to panic. And instead of going head-to-head in a public vote, they struck a deal. Alistair would pull the initiative, and in exchange, they'd pass the bill. And that compromise became the California Consumer Privacy Act, AB 375, signed into law on June 28, 2018 by Governor Jerry Brown. A millionaire real estate guy kickstarting the US privacy movement off a dinner party conversation. If that's not peak California, I literally don't know what is, but let's be clear. California didn't just pull CCPA out of nowhere. They had a lot of groundwork. Back in 2004, California passed something called the California Online Privacy Protection Act. It was one of the first laws in the US that required websites to post a privacy policy if they were collecting personal information. That meant for the first time ever, companies had to say out loud that they were collecting your data. Then in 2005, California passed another law called Shine the Light. It gave people the right to ask companies what personal data they were sharing with third parties. So if a company was selling your information to advertisers, they had to tell you. And these were very early attempts at transparency. They didn't give people much control, but they definitely forced companies to admit what they were doing. So by the time Alistair came along with this initiative, the state already had a privacy foundation, and CCPA was basically the moment that they built on it and turned transparency into real rights. This gave people something new, a legal toolkit to push back on data harvesting. It gave California the right to know what personal data businesses collect, ask for it to be deleted, and opt out of having it sold. And for the first time, you could now sue in the event of a data breach too, which is amazing. CCPA took effect on Jan 1, 2020, which meant for the first time, businesses were legally required to tell people the personal data that they were collecting and selling. Companies had to update their websites, train their staff, overhaul back-end systems, and prepare for consumer requests, like give me all the data you have on me or delete everything that you have on me. And even brick and mortar shops started posting signs outside saying, "We track you," as required by law. This is also a point of contention between policymakers and businesses, because all of a sudden businesses had to go back and figure out what data that they'd been collecting. And they had to figure out how to make it accessible or deletable on demand. For companies that had spent years vacuuming up user data with absolutely no obligation to explain anything, this was a huge operational lift. Privacy went from being something that was buried in terms of service to something that you could literally see at a checkout counter at a store. But California didn't stop there. In 2020, voters passed Proposition 24, aka the California Privacy Rights Act, CPRA, and it went into effect January 2023. Here's what changed. Now, instead of just being able to delete the data if it was wrong, you could request corrections. Businesses were held to stricter standards when handling sensitive data, things like your location, your race, your religion, your health, your information, your sexual orientation, and most importantly, they closed what's known as a cure period loophole, which used to give companies free passes if they violated your rights, if they fixed it fast enough. CPRA said, absolutely not, we're not doing that. Finally, CPRA created the California Privacy Protection Agency, the first standalone agency dedicated entirely to enforcing data privacy laws. They write the rules, they conduct investigations, they take companies to court if they're out of line. They also have data policies specific to kids, like the Age Appropriate Design Code Act, a law that requires apps and platforms to consider children's best interest by default, which means turning privacy protections on automatically, using age-appropriate language, running data risk assessments before launching new products for anybody under 18. This law is especially important right now given the rise of AI chatbots and algorithm-driven content targeting kids. You've probably seen the headlines. There are AI bots that are role-playing as therapists with minors, YouTube and TikTok that are serving up eating disorder content to young users, ChatGPT and Snapchat's AI is being used in ways that parents did not consent to. So California saying that you can't just release a tool and hope for the best. If kids are on your platform, you are responsible. And California has proven that it is possible to write strong, enforceable laws that protect our privacy and give us agency over our data. They set the standard, and they've shown every other state and federal government that policy can move tech culture, not the other way around. Okay, next up, Colorado. Let's talk about how they took California's blueprint and made it their own. See you next week.